Good afternoon, everyone. Thank you for joining our webinar this afternoon. My name is Andrew Reams, and I'm a licensing manager in the Innovation Institute Office for Technology Management. Today's webinar will introduce you to the Innovation Institute, the Invention evaluation process, as well as the Invention disclosure submission process. The goal of the Innovation Institute is to encourage and support innovation and entrepreneurship on campus, as well as in the community. The Institute brings together three offices: the Office of Technology Management, which facilitates the patenting, business opportunity development and licensing of Pitt Innovations; the Office of Enterprise Development, which works with the Office of Technology Management to develop startup venture opportunities around Pitt Innovations; and the Institute for Entrepreneurial Excellence, which provides entrepreneurial education as well as networking and assistance for local entrepreneurs and small businesses. The Innovation Institute is the hub for commercialization efforts at the university, which include educational opportunities in technology development and commercialization, and includes the annual course From Benchtop to Bedside, What Every Scientist Needs to Know, which begins again in January of 2016, as well as student business plan competitions that include the Wells Student Healthcare Entrepreneurship Competition and the Randall Family Big Idea Competition. The Innovation Institute also has courses and workshops in the area of startup development that includes entrepreneurial mentoring and networking. The university is focused, of course, on development of new knowledge, but we also place a very high priority on technology translation in order to develop new products and processes that will do good for the public, as well as to create economic growth. The business sector, for example, is a partner in research and development and provides funds as well as the knowledge and resources to develop and commercialize early-stage technologies. We have had tremendous growth in terms of entrepreneurship and innovation since our office started nearly 20 years ago. And just last year, we received over 300 invention disclosures from Pitt faculty, and we executed over 100, in fact 116 licenses and option agreements, and we had issued to the university 66 patents. We also have a very strong focus on development of startup companies whose nucleus is a Pitt technology. And in fact, last year we started 11 companies, and these companies are in a number of different areas, including in the areas of medical devices, diagnostics and therapeutics. This slide really demonstrates where the Invention disclosure form fits into our overall process for protection and commercialization of University of Pittsburgh technologies. The Invention disclosure form is the tool that we use and that investigators use to inform our office that they've developed an invention that they would like us to evaluate. After submission of the form, it's assigned to a licensing manager and then evaluated and considered by the licensing manager, but also very importantly by the University Technology Transfer Committee. This committee is made up of a group of peer scientists and administrators from the University of Pittsburgh. The technology is evaluated according to criteria, including whether it can be protected, enforced, and whether we can license, of course, the technology. And I'm going to discuss these aspects in more detail in the next couple of slides. If the Technology Transfer Committee agree to move forward, the university, especially in the area of the life sciences, the next step may well be to file a patent application, and then we would market the technology to try to identify a commercialization partner and enter into a license agreement. In parallel, the university works with the external patent counsel and will prosecute the patent application. This can be a long process and can take as long as 5 years or longer. So these processes of technology commercialization and patent prosecution take place alongside or in parallel with each other. The invention evaluation process includes identifying the level of intellectual property protection that might be possible, and this includes comparing the technology to other technologies that exist in the prior art, such as in the scientific literature and the patent literature. We also look at the size of the market. A large market size, for example, indicates there may be a good commercial opportunity for the technology. We also try to ascertain the level of pain that exists for a solution that the technology provides, indicating how interested a commercial partner might be in licensing the technology. The development stage of the technology and the inventor's ongoing interest to participate in the process is also very important. If the technology is at an early stage, but the inventor does not want to pursue it, then it might be difficult to get the attention of an industry partner who might want to see the technology developed further in the investigator's laboratory, perhaps through a sponsored research agreement, before they make a decision to license and commercialize the technology. And the questions that are included in the invention disclosure form are meant to tease out the answers to these issues that I've begun to describe to you. It's of course important to determine whether the invention can be protected, and in the life sciences, as I mentioned, this often involves filing a patent application, and we have to consider in this regard whether the invention meets the criteria of patentability, and that includes whether the technology is novel, in other words, that it's not already described in the public domain. And secondly, whether the invention might be considered obvious to one skilled in the art. A criteria for patentability is non-obviousness. For example, we'd have to consider whether another scientist working in the same field might look at several papers and then come up with the same invention, and therefore the invention might be determined to be obvious. But this is more of a grey area. We also look at whether a patent can be enforced. In other words, would you know if someone is infringing on the patent for the invention? And this might be difficult if it's a process, a product that's being utilized in an enclosed environment, for example, in a company's scientific laboratory. In that case, it might be difficult to know if someone's actually using it and infringing on the patent, and that's just something to consider. Another question is whether the technology can be licensed. If the technology is not of interest to a commercial partner, it might not be a good investment, and therefore it might not be an asset for the university. And these, again, are issues that we look at very carefully during our evaluation of the invention disclosure form submitted by the University of Pittsburgh investigator. So a patent application is very important. It can be considered to be a contract between the government and an inventor, such that in exchange for publicly disclosing an invention, in other words, providing technology that's not already in the public domain, that other investigators and other interested parties can build upon. In return for that, the government provides the investigator a limited period of time in which they can monopolize the exploitation of the technology. It's a right to prevent others from using your technology, or excluding others from making, using, or selling the technology. It doesn't necessarily mean that you can use it if by using it you end up infringing on someone else's technology. So that's another important consideration. The patent term is 20 years from the earliest filing date. It is an expensive process. The cost of obtaining a United States utility patent can be as much as $25,000, and it can be very expensive also to file in foreign countries. So filing an invention disclosure form is the first step in protecting your innovation, and it starts the invention evaluation process, as I previously mentioned. And that also includes an evaluation of the commercial potential for the technology. An invention disclosure should be filed early and often, and certainly before any public disclosure of your invention. A public disclosure before the university files a patent application will result in loss of patent rights. You should also be aware that very recently the United States moved to a new system called a first-to-file system, such that if two investigators independently develop the same invention, the patent will be awarded to the first person to file a patent application, even though they might not be the first person to have invented the technology or the invention. So this is another reason that we ask investigators to file invention disclosure forms with us as early as possible. Invention disclosures are accepted by our office at any time, but it's important to realize that when you file an invention disclosure, this in and of itself doesn't give you any protection. So you shouldn't think that as soon as you file an invention disclosure form with our office, you can now start freely talking about your invention. You're only protected once a patent application has been filed by the university. So let's discuss for a second what we mean by a public disclosure. In some aspects, this can be obvious, for instance, submission of a publication or presentation. But what might not be obvious to people is a student thesis sitting in a library which is available to the public. That is, in fact, a public disclosure. Or an abstract of a funded grant application, that too is a public disclosure. And non-public disclosures include lab meetings when you're discussing your invention with your colleagues here at the university, or an unfunded grant application, discussion of your invention with a company under a confidentiality agreement also is not a public disclosure. The confidentiality agreement would be developed and signed by the university. So, and unfunded grant applications are not public disclosures. So, please don't disclose any inventions before properly, before the intellectual property is properly protected. And if you have any questions in that regard, please contact one of the licensing managers or myself, indeed, at the Office of Technology Management. So as you begin to consider completing the invention disclosure form, you're going to need a title of the invention, the name and department of all innovators who made creative contributions to the invention. And that's important because there's a differential between an inventor for a patent application and an author on a scientific paper. Inventorship goes to the person who, or persons who conceive of the idea, not necessarily someone who reduces the idea to practice. But that's something that we can discuss with you during the invention evaluation process. And if you're not sure, you can certainly include their name. I don't think it's something that you should begin to worry about as you're beginning to complete your invention disclosure form. You will also have in mind a statement of how the invention works and how it's used. In completing the invention disclosure form, we ask that you compare your invention to similar technologies that already exist, so we can understand the improvements and advantages that your invention provides over technologies that are in the art. We also ask that you tell us the stage of development and list all government and non-government funding that contributed to development of the invention. Government funding requires a lot of reporting behind the scenes, and that is partly why just to explain why we ask for all this information, because we have to report to the government and other people, which I'll begin to explain. The government, for example, we need to report to them when we receive an invention disclosure, and if we decide to file a patent application. And in regard to foundation funding, there again can be certain stipulations associated with the funding, such as informing the foundation when we receive an invention disclosure. There might be terms in the agreement that include that language and other language. We also ask that you list all agreements associated with the invention, such as material transfer agreements and sponsored research agreements, since again these agreements may include certain intellectual property rights related to the invention. For example, the agreement could include a right of first offer for a company to negotiate an exclusive license for the invention. You should provide a list of past presentations or disclosures, as well as expected future presentations, so we're able to assess any issues relating to protecting intellectual property rights. For example, it's important that we know if you intend to disclose the technology, particularly in the near future, for example, at a scientific meeting, or there might be an imminent publication, in case there's anything we can do to prevent loss of intellectual property rights through the disclosure. We also ask that you provide a listing of potential commercial partners that you have been interacting with. This can be very helpful to us. Often from our experience, it's the inventor's contact with industry or contacts with industry that can result in a licensing or a license agreement. So to get started, please go to the Innovation Institute website. It's at innovation.pitt.edu and click on the button that you'll see on that page that says Invention Disclosure. And this will take you to the Invention Disclosure submission page on our website, and clicking the Submit Disclosure button on the right-hand side there starts the submission process. Now, this page provides a lot of useful information, such as some of the questions you'll be asked and you can begin to consider ahead of submitting the form. The cut-off dates for submitting an invention disclosure are also provided, telling you by when our office needs to receive your invention disclosure form by, in order that it can be reviewed at that month's Technology Transfer Committee meeting. And there's also a reminder on the page that a properly completed form helps our Patent Council to draft a more comprehensive patent strategy, which of course is in the investigators and the university's interest. So you begin by filling out the contact information and creating a username and password, and you'll use that username and password to log in to the system. After you log in, you see two sections. At the top of the page, there'll be an unsubmitted disclosure section for those disclosures that you're working on, and beneath it a section on those disclosure forms that you've submitted. And simply to add a new disclosure, you just go to the middle of the page and you select the Invention Disclosure button from the drop-down menu, and then you click Add New Disclosure here. And the next site will invite you to add the title of your innovation and select the IP type from the drop-down menu. We don't want you to worry about this too much. Likely you'll choose invention in the IP type, but there are other categories including copyright and know-how. But again, please don't worry about this too much. And the next page will ask you to add in the name of the innovators who worked on the innovation, and you just simply have to look for them or search for them on the database, which is on our system, and their name will be there. And then select the lead innovator and put a check next to who the lead innovator is. We want you to, of course, tell us as much as you're able to in synopsis fashion about your invention, including what problem it solves, what pain it solves in the marketplace, how it works, what the known applications are, and the benefits and features for your technology. And the next sections include questions that we've begun. I was describing why we ask these questions, but this is how we ask them on the actual invention disclosure form. There's a series of categories asking you to explain the novelty of your invention, the stage of development, for instance, information about the invention, how it relates to existing information in the art, known patents and patent applications that are already out there that you might be aware of. And then we ask you to provide information on sponsorship. And other categories ask for the disclosure dates. Also, you'll see there the first dissemination of the invention to a person outside of the university. Also importantly, we ask you to name any joint inventors. Some of the inventors who've participated in development of the technology might not be from the University of Pittsburgh. They might be from other organizations in the region, such as Duquesne University, CMU, UPMC. They might also be from companies as well. And that's important for us to understand in case they have also got they're entitled to intellectual property rights in the invention. And then, of course, there's a category asking you to share with us any commercialization interest that you might be aware of in the invention. So we have a section here which enables you to download all information that you've developed pertaining to the invention, and this could include papers, publications, grant information, certainly all data that you've developed, and that enables us to evaluate the science behind the invention. And please include as much information as you can. This is a tremendous help to us and essential. There is a summary form or section at the end of the invention disclosure form that will list all the information that you've filled in. And you have the ability to see if you want to change any information before you submit it at this stage, and you can print off a PDF form. And in fact, you don't have to complete the invention disclosure form all in one go. You can save it and make changes later. And you can also, as I mentioned, delete any information that you might have entered previously or add in any new information. You have the ability to do that. After you complete the form, there is a button on the page that says click Submit Disclosure. We have had instances in the past where people have thought that they've submitted the invention disclosure form, and we've been confused as to what's happened, and in fact they forgot or didn't realize they had to click the Submit Disclosure button. So that's just something for people to be aware of. And that will send the information to us at the Innovation Institute, and then you have the ability to download a PDF copy of the submitted invention disclosure form and send a paper copy. You must sign the form in the proper location, which I'll mention in the next slide as well, but then send a paper copy to the University of Pittsburgh Innovation Institute. All innovators who have contributed to the invention must sign the form entitled Acknowledgement Relating to Invention Disclosure and Assignment Agreement, and that form is printed off along with the invention disclosure form. And if there's a non-University of Pittsburgh innovator, we ask that they sign the acknowledgement form for non-University of Pittsburgh innovators. And this is just a copy of the PDF version of the form that you'll see once you print it off after you complete the invention disclosure form. And you can see that all the information, all the fields that we talked about are included here, including the abstract we discussed, and the development status of the technology, the sponsorship, which is very important. And the second page of the form discusses or second part of the form, the funding sources, disclosure dates, who the joint inventors are. And then you'll see right at the bottom, we ask that you proceed to the next series of forms to be signed, called the Acknowledgement and Assignment Agreement that I was just talking about. After submission, the form will be immediately assigned to a licensing manager, and the technology will be the licensing manager will make an appointment to discuss the technology and review the technology, the invention disclosure form with you. And at the end of the month, assuming that the technology was submitted by the cutoff date, the technology will then be reviewed by the Technology Transfer Committee. And you can expect to receive one of 4 decisions in regard to your invention. The committee will hopefully approve your invention, in which case we'll move forward to commercialize the invention. And if approved, our office will work with you to obtain intellectual property protection for the invention. Alternatively, we might decide that the technology is still at an early stage and we need more information, or the Technology Transfer Committee might require more information in order to make a decision on whether to protect the technology and file a patent application. Another decision might be that the technology is not patentable, perhaps due to novelty, because the technology or the invention is already seen to be present in the prior art, or is determined to be obvious based on technology or information already in the prior art. Now, if the university decides it doesn't want to continue to pursue the technology, but the investigator decides that this is something they'd like to pursue, we also have the option to release the technology to the investigator. So if you have an exciting innovation, we encourage you to start immediately to file an invention disclosure form. I can be contacted and I'm available to answer any questions that you might have. I encourage you not to hesitate in that regard. I'm available every Friday at the Hillman Cancer Center Research Pavilion from 9 to 5, and I encourage you to stop by and see me. I'd be delighted to talk with you. And just before we conclude, I just wanted to mention that I'm aware that there's a very important annual meeting that's coming up quickly on April the 16th, the American Association for Cancer Research, or AACR meeting. And I just saw that the abstract deadline for that was December the 1st, 2015. I'd like to encourage all of you to submit your abstracts to me so that I can review them to determine whether there might be an invention there or any intellectual property rights there that we might have the ability to protect. I'd also like to encourage you to join our next webinar, which is going to be more focused on the commercialization process and how to prepare for licensing, and that takes place on January the 19th at 12 noon. I'm happy to take questions just now, and we're taking questions online at the moment.
Yes, via the chat feature.
Via the chat feature, I'm told, so we're happy to do that. I'd like to thank you for taking time to listen to me this afternoon.
Andrew, I have a question.
Sure.
What is the Pitt policy for faculty royalties if they were to commercialize something? What are the standard policies around that?
Well, we have a policy entitled Patent Rights and Technology Transfer. That policy actually establishes the university ownership of intellectual property as a condition of use of university resources. And it also defines the proceeds distribution from licensing patents. And in fact, that's a good question because 30% of all proceeds after patent costs are covered actually go directly back to the investigator, and then another 15% to the investigator's laboratory. We have a further 30% that goes into a patent rights fund, and that helps us to finance future patenting of technologies for other investigators who work with us. 15% will go to the Office of Technology Management, and a further 10% will go to the Provost or the Senior Vice Chancellor for Health Sciences. Well, if there are no further questions, again, I'd like to encourage you to contact me at any time. I'm always thrilled to speak with and work with university investigators, and of course, one of my main priorities is to work with the University of Pittsburgh Cancer Institute investigators. Again, thank you for taking the time to listen to me this afternoon.